Welcome to today's program titled Securing the Invisible, Protecting Trade Secrets in the Age of Oversharing. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scan to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to Kevin, Mitch, and Andrew.
Well, good afternoon, everyone. My name is Mitch Robinson, and I'm Senior Counsel in the Atlanta office for Safer Shaw. I'm joined today and have the privilege to be joined by Andrew Saxon, who's a Senior Counsel in our office in San Francisco, and Kevin Mahoney, who is a partner in our Chicago office. And we are here to talk about something that has become synonymous with everyday life, and that's how we communicate in this day and age, and that's obviously through social media. A recent statistic that I saw that caught my eye was that over three-fourths, over 75% of those while at their workplace engage in social media for sometimes as much as an hour a day. And while some of that engagement is certainly welcomed by businesses and employers, there are certain ramifications that we should be aware of. And so, in thinking about those issues, we thought it would be good to have a conversation, which we hope to have today, that will inform you, regardless of what your standing is in the company, if you're outside counsel, if you're someone who is in HR, or you're just someone who's thinking about starting a business, about how to protect those things that are most important to the company, your trade secrets, the things that make your company move. And so we're going to go through a series of topics. If we could just go to the next slide and try to answer these questions. The first is how trade secrets are unintentionally exposed online. The second is employee training and prevention best practices. The third is tools, strategies, and response protocols. How do we effectively manage issues ahead of time? Internal response and containment tactics. And then finally, what is the current case law? What trends are we seeing and what are the legal implications? And then lastly, and I will encourage you throughout, if you have a question, please offer it. We will do our best to answer all questions that come our way. We'll deal with that. And Andrew, I guess I'll start with you. Can you give us a bit of context on some of the things that we are seeing clients and employers facing on a day-to-day basis in managing their workforce as it pertains to communication devices, social media, et cetera? I think you're on mute, Andrew.
Thank you for that, Mitch. I was thanking you for the introduction. Good morning, everybody. As Mitch mentioned, my name is Andrew Saxon. I'm a senior counsel here in San Francisco for Safer Shaw. And I do want to help orient this discussion today because, of course, we're here to talk about protecting your trade secrets. And we need to make sure we're on the same page with understanding what exactly a trade secret is. Next slide, please. And unfortunately, a trade secret, according to this court, is, quote, one of the most elusive and difficult concepts in the law to define. Next slide, please. But fortunately, we've got years of case law where courts, and now we have statutes that help elaborate and put boundaries on the concepts of trade secret and what trade secret misappropriation is. First, though, what constitutes a trade secret? Well, a trade secret is confidential information. It's not generally known or easily ascertainable. The information has independent economic value derived from being secret. And finally, and importantly, it's subject to the company's reasonable efforts to maintain secrecy. And so I think that'll be a theme today as to how a company takes these reasonable efforts in this world of social media. Next slide, please. I'm putting up on screen just some more background. This is a slide on the Uniform Trade Secrets Act. This was implemented throughout the country, state by state, largely. It's a source of trade secret law in your specific state, gives you its own definition and criteria for achieving trade secret status, defines misappropriation, sets forth remedies, cause of action. Next slide, please. Another source of law in the background here is the Federal Defend Trade Secrets Act. This is a federal statute giving rise to a federal cause of action. We've referred to it as the DTSA. It has its own definitions and various prongs. On screen is a definition of misappropriation, so you have that in these materials. Next slide, please. Who is stealing your data? Most commonly, this stat is 90% of misappropriation is your rogue employees and business partners. And vastly these days, it's all done electronically. Employees and business partners, those are the ones that have access to and familiarity with your computer systems. They're the ones with access to your information. And of course, technology is making it even easier to exfiltrate the data. Next slide, please. Again, just on the context here, what can't be a trade secret is information that's publicly available. So if you post about it in a journal, if there's blogs that are available, if it's on message board and they're just talking about your secret sauce, it's not a trade secret. Next slide, please. And again, just to emphasize the point here, I think throughout today is a reminder that public disclosure of your guarded trade secrets, if it's publicly disclosed, it loses its status as a trade secret, or can. This is what courts say, quote, "It is axiomatic that without secrecy, no trade secret can exist." Next slide, please. And just some bullets here on what level of security is required. Absolute secrecy and heroic measures are not required. You have to take, courts will look to see if companies are taking, quote, reasonable steps under those circumstances. And we'll get into that further. But if a trade secret is leaked without the company's fault, a court will be looking to see how the company responded to the leak. Was it aware of it? Does it have in place monitoring systems to look for a leak of trade secrets? And if the information does get out in public, how does the company respond to remove that information? Courts will carefully scrutinize the company's efforts, and these issues are subject to litigation. So when you're trying to enforce a trade secret, you're going to need to defend your actions to protect the secrecy of your trade secrets. Next slide, please. Finally, the sort of more of the meat of it for today, we're talking about ways in which trade secrets are being leaked online digitally. Put some examples here. Number one, this is where an employee simply posts information to a publicly available website, or potentially a website with security features that are insufficient to guard the secrecy of the information. Another example, use of unapproved cloud storage. I'm going to kind of go back and forth here a little bit, but that's, a common situation we see where you've got employees that are allowed to use Dropbox, iCloud, things like that during their employment. Then they're resigning, and in their offboarding procedures, the offboarding is not done sufficiently to ensure the former employee no longer has access to the information. So you wind up with confidential trade secret information remaining in some Dropbox accounts that your employee, potentially former employee, still has access to. There's sort of the old point 3 here is solicitations of clients and prospects through social media platforms. This is the fact pattern of the LinkedIn posts where an employee has all of your company clients and company prospects already friended and part of their network on LinkedIn and whatnot, and employees soliciting those contacts after departure. Number 4, employee relies on social media features like check-ins and likes. This is sort of interesting, but where a really, company looking, let's say you're a company, you're negotiating for an acquisition and it's hush-hush and secret. And meanwhile, you have employees that are checking in near the premises of that target company or liking and friending folks that work with the target company. You could see that it could start building a picture where suddenly a transaction that a company is attempting to keep secret suddenly becomes less secret. Next slide, please. We could continue to think of additional types of scenarios that we see, and so here are some additional ones. Number 6, keeping your contact information. Again, this has to do with company clients, company prospects. All that contact information is remaining in the possession of employees, and they're in jurisdictions where all that information is protected as trade secret. The company wants to take steps to make sure that employees are not able to pursue those contacts that are the company's. Again, using unsecured devices, storing records outside the company server. This gives rise to confidentiality concerns because you don't know or control the security features of these third-party platforms. Maybe you have license agreements, but your license lacks sufficient confidentiality obligations. Again, these are things that courts will scrutinize when you're trying to enforce a trade secret. You've got employee emails, emailing to third parties that don't have confidentiality obligations. You've got again, insufficient security measures to prevent cybersecurity breaches. Number 12, using AI to record and transcribe a confidential meeting that divulges confidential and trade secret information. So this is like I said, you've got now features where we can be recording verbatim and creating a transcript of a meeting. The companies should have the proper procedures and requirements in their handbooks to prevent that, or authorizing it only in limited circumstances. Because once that information is then transcribed, you're vulnerable to hacking or an employee misusing that information. Next slide, please.
And Andrew, can I
Yes.
ask you a question about that? Because this
Sure.
is one we're seeing clients on a regular basis now they're struggling with, right? Almost all of us are participating in some sort of video chat of some form, similar to what we're doing here. And with these integrated AI tools that allow for transcription, how are you advising clients? How are you sort of seeing this play out in real time? And what are some of the implications that you could think of because of that?
Yeah, thanks, Mitch, for the question. Yes, this is ongoing and happening now, and it's continuing to evolve as we get these new technologies that allow employees to come up with new ways to create vulnerabilities to the company's attempts to protect its trade secrets. So these days, if you're the way this comes up in our conversations with clients is monitoring for these types of platforms being used, developing proper language and policies that are properly disseminated to your employees that either restricts the use of them altogether, or potentially there may be ways to authorize the use in certain circumstances, but imposes obligations on the employees to protect that information. I mean, that policy language again is very useful if down the road if something happens and you need to be out there trying to get injunctive relief or trying to enforce a trade secret, and you can point at minimum to your policies. But that's one way we're approaching it these days, but also keeping abreast of the changes and evolution in technology. So that's how we're sort of tackling it. Mitch, have you seen it come up differently, or have you come up with different ways to tackle it?
I think you're spot on. I mean, I think that you got to make sure that you're up to date on what the integration is of AI. But I also think it is incumbent upon whoever is running that meeting and looking to protect that information, because sometimes, and we have scenarios, right, where someone is using a platform that maybe isn't your preferred platform, to either decide whether you're going to say, hey, we cannot use this platform, or I guess the alternative, and sometimes we advise it, is to be very explicit, particularly if it's being transcribed, that this is confidential, that the intent of this conversation is that it's not going to be recorded. That could play out as very good evidence should it go to a court and be before a judge on your side as well. And so it's one of these fluid things that I'm seeing. I don't know, Kevin, if you have any thoughts on it as well.
Yeah, in particular, these AI tools that now record a conversation and transcribe it and create notes on it boggle my mind. I recently had a witness tell me after deposition prep that he had recorded our discussion and was going to use an AI tool to create notes based on it. And you can imagine my reaction was, you did what now? But you run into all sorts of issues about releasing this information. You potentially run afoul of state wiretap issues when you're recording conversations with a third party without their knowledge. So again, to Andrew's point, having a clear policy up front as to what is allowed and what is not allowed, I think goes a long way. It's tough to keep abreast of changing technology, but I do think it's worth the initial investment.
Yeah, I just thought that was a really good point, Andrew. So thank you for making that one, because it's something I think all of us are facing on a frequent basis.
Perfect. And on a related note, the next slide has one final bullet here. Again, further on the use of this generative AI like ChatGPT. I cited a 2023 study from a cybersecurity company reporting 11% of the time workplace use of ChatGPT involved employees inputting company confidential information. Using ChatGPT gives rise to additional vulnerabilities that companies need to be aware of. You're talking first in ChatGPT and other generative AI, there is a learning period, right, where the machine, where the AI platform is being trained on large data sets. The use of that data set is now subject to the sort of whims and practices and security protocols of the AI platform. So that's a vulnerability. User prompts, where the employee is inputting confidential trade secret information, company information into ChatGPT, asking questions and inputting information. I've got some examples here. Excuse me. One example, Samsung engineers unintentionally leaking confidential data by feeding source code and meeting data into ChatGPT to ask ChatGPT to help them fix errors in the source code. This is the kind of thing that can happen. Obviously you may not be dealing with source code, but any confidential trade secret information that one of your employees is using and inputting into ChatGPT or similar creates more vulnerabilities. And I've got another bullet, a final bullet here is just more of a broader example. You in that scenario, you've got an executive or an employee inputting sales goals, marketing plans, customer names, anything you can think of. Down the road, someone else uses the same platform and asks questions about this company. And now the AI platform has the benefit of this confidential trade secret information and maybe feeds it back to this new user. And this, again, could potentially lead to destruction of a trade secret status. So these are the issues at stake and what we're talking about here, Mitch. I have happy to push it back to you to talk about our next subject.
Sure. And so I think it's fair to say that Andrew has painted a picture of a complicated world that we're currently in navigating the use of social media sites, communication tools that have become sort of inherent and fundamental to our day-to-day life. If we could just go to the next slide. I wanted to step back a bit because the implications of what we're talking about is not something that can be avoided. You see here that over 3 billion active users on a monthly basis on Facebook, over 2 billion active users on Instagram, over 1.12 billion active users on TikTok, and then over 300 million on LinkedIn, just to name a few, and including over 650 million on X. What was really interesting to me is the usage rate. And so Pew Research recently did a study where they found that 83% of Americans utilize YouTube. 68% utilize Facebook. So why is this important? It's not just about social media usage. If we go to the next slide, it's about how do you prepare your workforce in this day and age for these issues that are going to come about. There's a few things that we recommend that individuals think about when they're putting forward policies. And the first is defining what is a personal social media account and a non-personal social media account. Now, depending on your industry, this might sound trivial, but it is incredibly important, particularly, and I know Kevin's going to talk about this a little bit later, in litigating these actions and frankly, defending your trade secrets. We recommend that you are very clear about what is considered a personal use of social media and what's a non-personal use. I'll give you some examples. A non-personal use would be if you have an account through your business, and a lot of companies now, rightfully so, are encouraging social media use, and it is being used for that non-personal purpose, but we're finding that trade secrets are being compromised. So being very explicit about that distinction is vitally important. The scope of employer investigations. I want to put a pin in this because I think it is so, so very important. All of us, certainly here, Kevin and Andrew, can tell you a story about an employee who has a company device, who then engages in activities on that company device, whether it be social media or otherwise, and thinks that that activity is somehow not of interest to the company. Well, the easiest way to resolve a lot of that is to put it in writing, to let individuals know that if you are on a company device, whether it be a computer or a cell phone, that those are items that we can access and an employer can access. It allows for that knowledge to prevent the leakage of trade secrets. Obviously, mandatory access and exceptions. I recommend to a number of clients that they should block certain social media sites that are not of interest to the day-to-day workforce. An example of this would be if you are in an industry where it's not necessary to access Facebook, perhaps you think about blocking that site just to prevent access altogether or any concern about anything being compromised. And then certainly you should think about federal and state law regulations. There are a number of federal and state laws that are dealing with social media and dealing with access to social media. And so you should certainly reach out to attorneys like us to advise you on that. But you should be knowledgeable about the law as much as possible. And then lastly, this is a wrinkle that we have been talking about for some time now, frankly, close to a decade. The NLRB has provided very clear guidance that social media can be used as an organization tool. However, there is a distinction, and it's on the face of the guidance, that you can prevent the language that's just berating the workforce, berating your company. That type of language isn't permitted. And that distinction is important. Kevin and Andrew, I don't know if you've confronted particularly sort of this balance that a lot of our clients are dealing with and trying to be compliant with the NLRB guidance and also making sure that they're taking care of their workforce. Any examples would be great.
I mean, I can speak to an issue that I'm facing and seeing increasingly in the case law, which is you have an employee who takes confidential information, internal communications, internal chats, sends it to a personal email account or sends it to a personal Dropbox account, but later claims that those communications were part of a whistleblower investigation under the NLRB and that they didn't intend to disclose any information, but it's protected activity because it's part of them raising a protected complaint. That gets into some very thorny areas about what the employee was allowed to take and what they are not, and a lot of it depends on use. And particularly when you're asking for an injunction against activity that may be protected by the NLRB, that really gets you into some difficult positions. So to Mitch's point, an ounce of prevention up front and having clear policies and clear guidelines about what employees can use and taking into account, do my employees actually need to be able to access Dropbox from their personal computers, I think can save a whole lot of pain down the road.
Yeah. And I saw we have a question here, which actually the timing is good. I'll send it out to all of us. It talks about the burden of proof. And it says the reversal of the burden of proof in trade secrets litigation. Well, that actually fits squarely into what we're talking about right here. Knowing that an employer has a burden to prove that these are confidential or proprietary items that they're looking to protect. All of these things are vitally important. And we're going to get into sort of some of the things you can be doing during an employee's employment and then afterwards to also protect those trade secrets in a moment. But in my view, the first step is setting up policies that make it very clear about what's permitted and what is not permitted. And then throughout, making sure that those items that are considered trade secrets or valuable for your company are seen as such, and that you are creating safeguards throughout. I don't know if anybody else has any thoughts on the question we just received from somebody that's listening in.
My initial thought, and all I can speak to, is what I've seen probably over the last 5 years in cases, and I would say particularly in California, is that this idea, and Andrew mentioned it earlier about the difficulty in defining a trade secret. Courts used to give you a little bit more leeway in alleging what a trade secret was up front and then using discovery to hone and refine what the alleged misappropriated trade secret was. I think those days are coming to a close. Courts are recognizing that that process could be a little bit misused by allowing a plaintiff to go on a fishing expedition into the defendant's, which is sometimes a competitor's, trade secrets, and figure out what their alleged trade secrets are later on. I think courts are being a lot more exacting these days on requiring a plaintiff to pretty clearly define up front, okay, what is it exactly that you are claiming as a trade secret in this case, rather than giving them that kind of deference that I think trade secret plaintiffs used to enjoy a little bit more.
Yep. Andrew, anything from you on that point?
No, just to add, to echo the thoughts already expressed regarding the ounce of prevention, having your policies up front being comprehensive. And I think with those policies also to think more broadly, also to include onboarding and offboarding procedures and the way you go about that to, again, also to protect your trade secrets and help you establish that you are enforcing a trade secret.
Yeah, and that's a nice segue. We can go to the next slide. And so to that question, one of the things, and I've seen it in my practice as well, that is going to be vitally important is that plaintiffs who are looking to enforce a trade secret understand that the monitoring and enforcement from the onset of an employee's employment to afterwards is important and moving swiftly. And I know that Kevin will speak to this a little bit later, and timeliness is, of course, important, but there's other things that you can do. If we could just go to the next slide. Limit access on a need-to-know basis. And so we represent oftentimes employers who have a workforce that is international, certainly across the US. And there are chats and Teams groups, Slack groups that are created. You should be very, very, very intentional about limiting access to particularly proprietary information. Now, why is that important? And I'll just give you an example from my practice. There is nothing better than going to a court and saying, Your Honor, this is information that is vitally important to our company because of X, Y, and Z. And recognizing that, here are the things that we have done to safeguard that information. And a part of that is making sure that it's not easily available to everyone within the workforce. And so really thinking about limiting access in that way is incredibly important. Another thing that I recommend is setting up and routinely reviewing downloads and access to critical information and documents. A lot of times we get from clients and individuals that we speak with, well, that sounds fine and dandy, but what are some easy ways that I can tackle this? One that I'm aware of, I know a lot of employers use Microsoft Teams. And the fact pattern that we so often hear is there's a document that's attached to a Microsoft Teams group. And, we had a limited group, but it could be downloaded. And so we don't know who downloaded it and when. Well, there's apps as sort of a first step, like Microsoft Purview, which is oftentimes in the Microsoft suite, which can be used particularly for documents that you consider proprietary, that you can lean on, to the second point, to monitor tools in real time and after the fact. Obviously, label confidential documents, but I do want to put forward a caveat here. Merely labeling something confidential, and this is something that I think all of us will agree on, is not enough. The actual practices about how you are treating that document are most important. And to the extent you can show an outline of how you are treating those documents, that's even better. And then, of course, training. I think all of us will agree that the more you train, the better off you will be in protecting your workforce. Any thoughts on that, Andrew and Kevin, before we go to the next slide?
I think you've said it. It's a comprehensive, multi-pronged approach that we're repeating here, but is from soup to nuts, making sure that your trade secrets are protected and you're able to marshal a list and create of the steps that you're taking to do so. That those are persuasive to the court, and a lot of times these cases involve emergency relief, expedited basis, expedited discovery. So having this at your fingertips and being able to prove it is very useful in the litigation setting.
Yeah. And so next slide. And then so, a lot of this doesn't end when the employee leaves. In fact, and this will not be a surprise probably to anyone that's tuning in, after an employee leaves the company is where we find a lot of the issues occurring. And so conducting an exit interview is always advisable. Personally, and almost all of the cases that I deal with, when I'm advising a client, an IT review immediately after an employee leaves is so valuable. It gives you a lot of information, and oftentimes it will tip you off to someone that might be a high risk employee versus someone who's a lower risk employee. Ensuring the return of company policy, and I do want to just put a bookmark on this, because it's not just ensuring the return, it's also making sure that you are capturing what's on that device. A lot of times we will see devices being returned and they're immediately wiped. Well, if you have somebody who's taken all of this data from that device, it would have been much easier to prove your case if we had the device. We could have run forensics on it, et cetera. And so that's an important step. Reminder to employees, this should be sort of part of your day-to-day protocol when an employee leaves, sending them reminders, reminding them of the continuing obligations. It's so important. And then obviously assess the need for forensic information. This is not something that's needed in all cases, but it is something if you have serious concern or if that person was privy to particularly sensitive information, you might want to look into. And then you should look at email and phone activity. I will tell you, I am constantly shocked at how many employees who have lined up in employment with another employer 2 to 3 months prior to their departure decide that they are going to send emails from their work account to their personal account. It is critical information. It's oftentimes information that you see in litigation across the country leaned on heavily. And then the other thing I would encourage is we now have the ability to see what is printed. So oftentimes another way in which we see individuals that want to take trade secrets that think they are being a little bit more savvy is they will print out documents, they'll print out information and carry it with them thinking that that will get around their obligations. It does not and should not. And so those are very, very good ways that you protect your information. And again, they are so important in proving a prima facie case should you choose to be a plaintiff in a case defending a trade secret. But I do want to go to Kevin here because what we just talked about is sort of best practices, right? And I think all of us know that in our work, no good deed goes unpunished. And so what happens when that employer has done everything right, everything we've advised, and you still got the employee who has disclosed documents, Kevin?
Thanks, Mitch. Next slide. You're absolutely right. I mean, we've had clients in situations where they've put out the most robust monitoring and tracking software that you can imagine, and an unauthorized disclosure still happens. It's just the world we're living in now. So you can certainly minimize this threat, but I don't know that there is a way to get rid of it entirely. So what happens when, despite your best efforts, there has been an unauthorized disclosure of your confidential information through social media or to a personal electronic account, whether it be Dropbox or a personal email account? Next slide. Once you get over the initial panic, there's a few initial considerations that I think will largely dictate how you deal with such an event. And really, one thing that comes up repeatedly is determining what exactly are you dealing with? Are you dealing with a bad actor who intends to misappropriate and share or use your trade secrets? Or are you dealing with somebody who maybe just didn't use the best judgment in deciding what they were going to put on their social media account? Those are two very divergent paths, and they come with very different costs for your organization. The former, the bad actor, tends to be a whole lot more costly in the long run when you factor in potential legal fees and the cost of forensic examination. As with any trade secret lawsuit, the speed at which you move is going to play a large part in determining what kind of relief you can ultimately get. Andrew mentioned earlier that the general rule is that once your trade secret is publicly disclosed, that it loses its protectable status. Courts have softened that a little bit in recent years with regards to postings online. They've generally recognized that posting something on a blog that a total of 5 people might read is a little bit different than putting it on the front page of the Wall Street Journal. In that case, the Wall Street Journal, your trade secret's out there, it's gone. It's no longer a trade secret. But courts have found that in the case of the former, if it's not something that was widely disseminated or widely used, if the employer or trade secret holder takes appropriate immediate steps to try and claw that back, then the information can still qualify as a trade secret, even if it was publicly disclosed for a period of time. In terms of what you're dealing with, a bad actor versus maybe just an inadvertent disclosure or an overly exuberant employee, I can tell you based on my own experience that in terms of remediation, having material that you want removed from social media and from the internet is going to be about 1,000 times easier if you have a current employee who still has a vested interest in remaining employed to assist you with this process, rather than dealing with an employee who is terminated or a former employee who may not be as likely to cooperate with whatever your requests are going to be. Sometimes the initial panic reaction when you're faced with this situation, an employee has posted a trade secret online, is immediate termination. And what I would suggest is that an administrative leave so that they can continue to cooperate with you throughout that process may be the way to go. A big part of that is that there is now a patchwork of state laws. California and Colorado are the first ones that come to top of mind that restrict the ability of the employer to ask an employee for social media credentials. So you need to be careful if you find out that an employee has posted trade secret information online, depending on what state you're located in as the employer, and depending on what state your employee is located in, you may face civil penalties even for asking them to have the credentials, the password and the username for that account turned over to you so that you can perform your own remediation. Again, having a cooperative employee tends to make things go a whole lot smoother than having somebody who may now have a grudge against the company. Next slide. Another initial consideration in determining what path you're going to take in responding to an unauthorized disclosure is figuring out who exactly owns this account. As Mitch pointed out, a strong, clear policy on this tends to go a long way. The seminal case on this was Phone Dog versus Kravitz. It was a case out of California where an employee had created a Twitter handle with the name Phone Dog Noah. Phone Dog was the company he worked for, Noah was his first name. And he used that account to advertise the company's products, interact with customers, keep a customer list in the contacts on Twitter, all of which the company claimed as its own information. When he left, he changed the name of the handle of that Twitter account to his name instead of Phone Dog, but kept all of the information on it, kept the contacts. Phone Dog filed suit in that case, and they claimed that the actual credentials for the Twitter account, in other words, the username and the password, that those were its trade secrets. And that was a theory that passed a motion to dismiss. The case ultimately settled, but there is still a viable theory that account credentials themselves can be the trade secrets of the employer. But again, the usual decision point in those cases, as Mitch pointed out, is there a clear policy that the employer can point to say, this is clearly a work account, this is not a personal account, and this is company property rather than the property of the individual.
Hey, Kevin.
Yeah.
On that point, because I think that's an important one, and I touched on it a little bit, but I think this case illuminates it, right? Are there ways, in addition to defining what is a personal account and a non-personal account, that employers can implement in creating this distinction so a case like Phone Dog is even cleaner?
Yeah, I think two things come to top of mind. First is having a clear policy about if you have customer contacts on Twitter, defining those as the property of the company, even if it is a personal account. I mean, if you are in marketing and you are using Twitter to advertise your company's products and to develop a customer base, then those contacts, there is a very reasonable case to be made out by the employer that that's what you were paying this individual to do, to cultivate that contact list. That was what happened in this case, Christo versus Beatport, that I've cited in this slide. That was a case where the plaintiff employer was a DJ company, and they advertised their services through MySpace, and they had cultivated a large following through their MySpace account. The individual who ran it, the MySpace account, had left the company and claimed that that was his property. And the employer raised a successful claim that no, the MySpace account and all of the contact information on it is actually our property. So I think having a clear policy as to what information resides on the account, who that belongs to. And then the second thing I would recommend is having a clear policy as to whether or not employees can use your company's name or trademark in their personal email account. If you're allowing employees to use your company's name as part of their Twitter handle or their Instagram handle, then, or your trademarks for that matter, or your copyrighted logos, you should not be surprised when an issue comes up as to whether or not that's company property or whether or not that's personal property. So I think having a clear policy up front eliminates some of that risk and eliminates that potential for confusion on down the road. One point I want to raise here is that you can have the clearest policy in the world, but it's important that you also have the means set up to change the access to an account if it comes to it. We had a case last year where it was clearly a company-owned account. There was a clear policy that the account was owned by the company, but the only individual who had the means to access it had recently left under bad terms. And it was her cell phone that the two-factor authentication required to change the password would go to. She refused to cooperate unless the company paid her a sizable settlement. So understanding up front before issues arise, okay, if the need comes to take control over this social media account, are we able to do so without the involvement of a single employee? Those are the kind of things that, again, a little bit of prevention up front and clear policies can prevent some real headaches down the road. Next slide. Andrew mentioned some of the implications earlier about what can happen when employees, even inadvertently, share information online that the company later wants to qualify or characterize as a trade secret. There's a case a few years ago, Sasco Group versus Courtney. This was out of the Eastern District of New York, where a plaintiff employer claimed that the identities of its customers were a trade secret. That's something that a lot of our clients allege, particularly in the financial services industry. The problem in that case was that the defendant was able to demonstrate that all of the customers and their identity as customers of the plaintiff was information that was readily available online. She had colleagues who were posting photos with customers, identifying the customers as such. She had other colleagues who were checking into the customer's location and identifying themselves as being there on a work call. These are the kind of things that may seem innocuous at first, but I think instructing your workforce up front that this could become an issue down the road helps present these issues. We had another case where the company wanted to claim that its overall sales figures were a piece of confidential information. Well, that became a real problem when some of its employees had publicly posted photos of themselves at a company-wide event with the overall sales figures behind them being projected on a screen in bold that was clearly visible on the internet. So making sure that employees understand that even if they aren't intending to disclose trade secrets, that they can inadvertently do so through careless actions, I think gets employees thinking about those kind of things up front. I guess I'm probably too old for it, but these day in the life videos, Mitch and Andrew, I don't know if you've seen these, where an employee goes into their office and they videotape, they take a video of what they're doing in the office. Those give me an awful lot of heartburn. I don't know about the two of you, because you're having someone walking around, things are in the background. For all I know, there are customers walking around the office who may not want to be identified. Letting employees know what is and what is not acceptable up front can sometimes prevent some of these inadvertent disclosure issues. Next slide.
Yeah, Kevin, I was going to say, as you go to the next slide, I mean, that slope has become even more slippery. I have the same type of heartburn because part of the marketing that we're seeing employers doing is talking about how great it is to be an employee of the company. And so having that balance of what's acceptable and what is not acceptable, I think has become more complicated, right? And all of these implications are important to note. So I thought that was a good point you made there.
And before I go on to the next, we have another question about whether or not there are AI-enhanced forensic tools for investigation of trade secret disclosure cases. I think in the investigation end there are, but what I'm more aware of is on the prevention end. There are AI-powered monitoring software that companies can implement that, I'll give you an example, will track every employee's use of Gmail. And your IT department will get an alert if, say, an employee is sending a document that originated at the company to a personal Gmail account. Now, again, that may be an innocuous situation where the employee says, oh, I just need to print something off at home. But there are some fairly robust tools out there to help alert you and monitor in real time what is going on with your confidential information and trade secrets and how employees are using those. Let's say, though, that you do not have a cooperative employee, you're dealing with a bad actor, and your trade secrets are still available in the public sphere. Well, unfortunately, the nuclear option is filing a lawsuit, and it is almost always, as Andrew mentioned earlier, under the Defend Trade Secrets Act, which provides you a federal question and ability to get into federal court regardless of the diversity of citizenship of the parties. You are usually, in this case, going to be asking for a temporary restraining order. So it's important that you consider what obligations you have to preserve evidence. Mitch, I think you mentioned a little bit ago that some companies, the policy is as soon as the device is returned, it gets wiped so that it can be reused by another employee. Well, if that happens, and then you determine that there was an unauthorized disclosure of your trade secrets, very often your best evidence in the case has just been wiped from the company device. The court's not going to look kindly upon that. So consider implementing a pause period before a device is wiped and used by another employee so you can make sure that if there is any relevant evidence that it's being preserved and that nothing's being destroyed before you may know about an issue. In terms of these temporary restraining order cases, and this really gets into some of the issues that Mitch mentioned earlier, where there are NLRB concerns, consider the relief you're asking for, because an injunction asking somebody to be prohibited from disclosing trade secrets is one thing. An injunction ordering somebody to take down a publication from their blog, especially if it concerns a matter of public interest, starts to raise some concerns with the First Amendment and about an affirmative mandatory injunction. So you want to be careful about how you frame the request that you're making to the court to have your trade secrets removed from the public sphere. And if it's too late for injunctive relief, of course, there are options for damages. Although I will say that in the case of an individual, especially with concerns about collectability of damages, that your best option for relief is almost always going to be a request for immediate emergency injunction. Next slide, please. So what are some of the recent cases that we're seeing, and how has the case law been developing? I think what we're seeing, particularly over the last 4 or 5 years, is an increase in the means by which employees are divulging confidential information and trade secrets, and particularly with the rise of remote work after 2020, some of the challenges that employers are facing with employees who may be located overseas. Next slide. Google versus Roy was a case that was filed last November in the Western District of Texas. This is a case where a former employee of Google, an engineer, was posting pictures of a confidential chip design on his social media. I believe it was a LinkedIn account in this case. And this one fell into the bad actor camp. This individual had been posting chip information, had been taunting Google on social media, indicating that he was going to keep doing so and they couldn't stop him. For a while, the individual was doing so from India. Google was only able to pursue him once it discovered that he had moved back to the United States in Austin. And I don't mean to say that there's no method of dealing with somebody overseas if you're trying to get an injunction, but anybody who has tried that process knows that it is an awfully complicated process to try and get a temporary restraining order or an injunction against somebody who is not under the U.S. jurisdiction and who may be in a jurisdiction that is not a signatory to the Hague Convention. You may be looking at a year and a half just to get that individual served in the first place, in which case your trade secret is gone. Next slide. Sometimes even the innocent actor that doesn't have any malicious intent can present some unique challenges. This is a case we had within the past 2 years for a client where, again, a software engineer in this case had, and this is why these day in the life videos drive me nuts, he had taken a photo of his team in front of a whiteboard. And again, this was supposed to be a nice group photo. The problem was, if you look closely at the whiteboard, it had some fairly detailed specifications of an unreleased prototype that the company was developing. And the individual took these photos and posted them to his personal blog. The blog was not well trafficked. The company didn't find out about it until nearly 9 or 10 months later when somebody alerted it that, hey, by the way, we found these pictures. It sure looks like this is a prototype, by which point the employee had not been working there for 8 or 9 months. Now, they were able to get cooperation in removing the blog post, but what really became a problem was determining where the information had been posted from. And this is where a solid forensics vendor can really make the difference in this kind of litigation. In this case, we knew that the individual had not used his work-issued computer to post these photos to a blog, and the only device that he had identified had no evidence that the images were ever on that device as well. So the images had to come from somewhere before they were posted. We eventually were able to track it down to he had used his girlfriend's computer to do so, but it just goes to show that even with a cooperative employee, even with somebody who doesn't have any malicious intent, this can create a lot of cost and it can create a lot of work in getting these materials removed and in ensuring that your trade secrets don't still live out there somewhere on some device that can still be misused. Next slide. I wanted to say a particular word about GitHub. I saw this case out of China, but we've seen other cases similar to it here in the United States. GitHub is a an online platform that software engineers can use to store, share, and download computer source code. And we are seeing a marked increase in cases where software engineers have done one of two things. Either they have taken source code that they developed at work, which they consider to be not confidential or just utilitarian code, and they share it on GitHub, or they take code from GitHub and incorporate it into their work for the company. Either one is a problem. In the former case, obviously there may be a difference of opinion between the company and the engineer as to what code is actually confidential. And in the later case, if your employee has taken code from GitHub and put it into the source code for your company's work, you've now opened yourself up to a possibility third-party claim that your invention now incorporates their intellectual property. Next slide. The last resort, and I'll just mention this briefly because obviously this is a pretty extreme remedy, is that there are criminal penalties. The DTSA is primarily a civil statute, but it did also enhance criminal penalties under the Electronic Espionage Act. So if you are faced with a recalcitrant employee, somebody that can't cooperate, somebody who is ignoring a court order, and particularly somebody who you believe may be about to leave the U.S. jurisdiction, then you may want to consider filing a criminal complaint. That's not something that any company should take lightly, but at the end of the day, as it was in this case, again, this is another Google engineer who was indicted last year for using social media and personal accounts to offload personal information. That may be the only resort if you don't have time to get into court and get an injunction. Next slide. I think we've got a couple of questions, and there's a CLE code as well.
Yeah, we will. So for those of you that have a phone, you can just scan the QR here. But let me just read the attendance verification code here so people have it. I'll read it a few times because if you're like me, this is an important part of your participation. It's SS6000. Say it again, SS6000. I think, Kevin, you know, to sort of the points that you were making, you know, the litigation that I foresee just happening more and more, and this goes back to what Andrew was talking about before, and I just want to emphasize it as we close here, is that as we see this integration of AI with the development of all of these social media tools, and the two are going to become synonymous with each other, I believe. We're seeing on Instagram now, literally AI Instagram accounts that have been configured. And I think it is very important for employers to start thinking about which one of these social media devices within the workspace are permitted, if there are safeguards that they can put forward that prevent certain sites that they maybe have concerns about on the front end, putting that forward immediately. But I think I do not foresee, and I'd be interested, Kevin, as we conclude, sort of your thoughts on whether we think this is going to be something where we're going to see an uptick in litigation over the next few years or a downtick.
I think you're right, and from my perspective, I think it's going to be uptick. You know, in 2020 and a couple of years after, it seemed like the real focus was going to be on remote work and remote workers and how people were offloading information through hybrid work means. And now over the past couple of years, it sure seems like the focus is going to be on these AI tools and the threats that they present in terms of how employees, intentionally or not, can disclose confidential information and trade secrets.
Yeah. Well, thank you, gentlemen, for a great session and conversation. All of our information is on the screen here. Feel free to reach out to us. Kevin, Andrews, always a pleasure chatting with you about something that keeps us up on a regular basis.
Thanks very much, Mitch, and thanks to everybody attending today. If you have any questions, please reach out.
Thank you all.
Take care.